If you're married to a US citizen, engaged to one, or even thinking about starting the marriage green card process this year, you need to stop and pay attention for a few minutes because what worked even 2 or 3 years ago can now trigger delays, denials, or interviews that feel less like conversations and more like interrogations. And the most dangerous part, most couples don't realize anything has changed until they're already deep in the process, staring at a request for more evidence or walking out of an interview, wondering what just went wrong. Being legally married is no longer enough. A marriage certificate by itself doesn't protect you. Love doesn't protect you. Even good intentions don't protect you. What matters now is how your relationship looks through the eyes of an immigration officer trained to assume nothing and verify everything. Under the new enforcement priorities moving into 2026, scrutiny has intensified. Interviews are becoming nearly universal, and small inconsistencies are being treated more seriously than ever. Real couples, genuine, loving couples, are getting tripped up not because their marriage is fake, but because they underestimated how closely their lives would be examined. And if you think approval means you're safe, especially with a conditional green card, there's another layer you need to understand. In the next few minutes, I'm going to break down exactly what's changed, what officers are really looking for, and how to protect your case before it becomes a stressful, expensive nightmare. Hi, I'm Sofia, and for years I've been breaking down immigration rules in plain English so real families can understand what's actually happening behind the scenes. I've watched patterns in approvals and denials, shifts in enforcement priorities, and the subtle changes that don't always make headlines but absolutely affect real marriages. And right now, the marriage-based green card process is less forgiving than it used to be. Today, I'm going to walk you through what's different in 2026, how the interview process has evolved, what kinds of evidence actually carry weight, the red flags that trigger extra scrutiny, and the mistakes that even honest couples are still making. Because this isn't about fear, it's about preparation. And once you understand how officers think, you can position your case in a way that protects your future instead of putting it at risk. Before we go deeper into what's changed, we need to make sure we're completely clear on how a marriage-based green card is supposed to work, at least on paper. When a United States citizen or lawful permanent resident marries a foreign national, they can sponsor that spouse for permanent residence. Permanent residence, commonly called a green card, allows the foreign spouse to live and work in the United States long term. But even at this early stage, timing matters more than most people realize. If the marriage is less than 2 years old at the time the green card is approved, the government issues what's called a conditional green card. It's valid for 2 years, not 10. Near the end of those 2 years, the couple must file another petition to remove those conditions and prove the marriage is still genuine and ongoing. If the marriage has already passed the 2-year mark when the case is approved, then the foreign spouse typically receives a 10-year green card from the start. Now, the process itself can unfold in two main ways. If the foreign spouse is already inside the United States and eligible, they may apply to adjust status without leaving the country. If they're outside the US, the case usually goes through consular processing at a US embassy or consulate abroad. Both paths involve forms, filing fees, background checks, biometrics, medical exams, document submissions, and ultimately an interview. On paper, it sounds structured, linear, predictable. Submit the right forms, provide the marriage certificate, attend the interview, wait for approval. But here's where many couples make a critical mistake. They treat this like paperwork when it's actually an investigation, and that shift in mindset is exactly what has changed under the 2026 enforcement climate. Marriage-based green cards have always been examined carefully, but the level of scrutiny has noticeably increased. Officers are now trained with a much stronger fraud detection lens, especially in marriage cases. Why? Because historically, marriage fraud has been one of the most common forms of immigration fraud. So instead of assuming a marriage is legitimate unless proven otherwise, officers are increasingly approaching cases with a trust but verify mindset. And in many situations, it feels more like verify everything. One of the clearest signs of this shift is the interview itself. Years ago, some couples were approved without ever sitting down face-to-face with an officer. That's no longer something you should expect. Interviews are now standard in most marriage-based cases, and they're not casual chats. They're structured, deliberate, and often detailed to the point of discomfort. Officers may separate spouses and compare answers side by side. They may ask about how you met, who initiated the relationship, what your first date looked like, how your home is arranged, which side of the bed each of you sleeps on, what time your spouse leaves for work, what you did last weekend, which relatives you've met, or how holidays are typically spent. The purpose isn't to embarrass you, it's to identify lived experience. Real couples develop shared routines, shared memories, shared patterns. Officers are looking for that natural alignment. And here's the part that surprises people. It's usually not one wrong answer that creates problems. It's patterns of inconsistency, small differences in answers about daily life, vague descriptions where specifics would normally exist, confusion about basic routines. Genuine couples sometimes stumble simply because they underestimate how closely their answers are compared. They assume love will be obvious. But immigration doesn't evaluate emotion. It evaluates consistency and evidence. And this increased scrutiny doesn't just show up in interviews, it shows up in paperwork too. Requests for additional evidence are becoming more common, more detailed, and less forgiving. Officers aren't satisfied with surface level documentation anymore. They want to see that two lives are truly intertwined financially, physically, socially, and over time. And if that proof isn't strong from the beginning, the case can slow down dramatically. So, the real question becomes, what kind of evidence actually convinces them? And what kind raises red flags without you even realizing it? That's where things start to get even more important. So let's step inside that interview room for a moment, because this is where the reality of the process hits hardest for most couples. You walk in thinking you're there to confirm your marriage, but from the officer's perspective, they're there to test it. And the way they do that isn't by asking dramatic movie-style questions. It's by focusing on the ordinary details of daily life, the things real couples don't rehearse. You might be asked how you met and who made the first move. That sounds simple until one of you says it was at a friend's birthday party and the other says it was a casual group dinner. You might be asked what side of the bed each of you sleeps on, who wakes up first, how chores are divided, what streaming shows you're watching together, what you did last weekend, or what your spouse typically orders at a restaurant. Officers may ask about your in-laws' birthdays, work schedules, or even how your living room is arranged. And in some cases, especially when there are perceived red flags, spouses are separated and questioned individually. Their answers are then compared line by line. Now, here's the nuance that most people miss. Officers are not expecting perfection. They know humans forget small things, but they're trained to recognize natural consistency versus memorized alignment. Real couples don't give identical robotic answers. They give answers that overlap in a way that reflects shared experience. If both spouses struggle to describe basic routines, or if timelines don't match, or if answers feel vague and generalized, that's when concerns start to build. It's rarely one mismatch. It's the accumulation of small inconsistencies that shifts a case from smooth to complicated. And nerves make this worse. Completely genuine couples sometimes stumble because they didn't review what they submitted. They forget exact dates. They mix up travel timelines. They assume close enough is fine. But immigration officers don't evaluate close enough. They evaluate credibility. Once credibility is questioned, everything else in the file is viewed through a different lens. This is why preparation matters. Not scripting answers, not memorizing fake detail, but actually reviewing your case together, going through your forms, talking through your shared history so that when you answer it feels natural instead of forced. If this breakdown is already helping you see the process more clearly, make sure you're subscribed to Global Visa Guide so you don't miss guides and updates like this, because policies shift and staying informed can make the difference between months of stress and a smooth approval. Now let's talk about evidence, because what you submit on paper carries just as much weight as what you say in person, sometimes more. And this is another area where 2026 standards are noticeably stricter. A marriage certificate proves you're legally married. It does not prove the marriage is real. That's the part many couples misunderstand. The government isn't evaluating whether a ceremony happened. They're evaluating whether two lives are genuinely combined. Strong evidence usually falls into one powerful category: shared responsibility over time, joint leases or mortgages that show cohabitation, bank accounts that aren't just opened, but actively used by both spouses, insurance policies, listing each other as beneficiaries, joint tax returns, utility bills with both names, car titles, travel records, photos spanning months or years, not just one wedding album or a single weekend of staged pictures. Officers look at patterns. If a joint bank account was opened 2 weeks before filing and shows almost no activity, that raises questions. If every photo submitted was clearly taken on the same day in different outfits, that can look manufactured, and timing matters more than most couples realize. Officers often compare when documents were created relative to when the immigration petition was filed. Evidence that naturally accumulated over the course of a relationship carries far more weight than documents that appear suddenly once immigration paperwork begins. It's not about having a thick stack of papers, it's about showing progression, how the relationship developed, how responsibilities merged, how daily life intertwined. They also consider social recognition. Do friends and family know you as a couple? Are there affidavits from people who've witnessed your relationship? Are there shared invitations, joint memberships, holiday photos across multiple years? Immigration officers are trained to distinguish between evidence that reflects a lived-in relationship and evidence that looks assembled for a case file. And here's the important part. No single document guarantees approval. It's the total picture, the consistency between your forms, your interview answers, and your documentation. When those elements align naturally, cases move smoother. When they don't, scrutiny increases quickly. But even strong documentation can trigger extra attention if certain red flags are present. And understanding those red flags before you file can dramatically change how you prepare your case. Now, we need to talk about something that makes a lot of couples uncomfortable: red flags. Not because they automatically mean your case will be denied, but because they change how closely your file is examined. And under the current 2026 enforcement mindset, red flags don't just sit quietly in your file, they influence the entire tone of your review. A large age difference, a relationship that moved very quickly from meeting to marriage, major differences in education or financial background, not sharing a common language fluently, cultural or religious differences, marrying shortly after a visa overstay, a status violation or a prior removal issue, meeting online and spending most of the relationship long distance. None of these factors by themselves disqualify you. Real love exists in every one of those situations, but statistically, these patterns have appeared in fraudulent cases in the past. So, officers are trained to pay closer attention when they see them. And here's the key. One red flag doesn't sink a case. Even two might not. What creates problems is when red flags appear without strong, consistent evidence to balance them. If you have a large age gap and very limited shared financial documentation, if you married quickly and have minimal proof of time spent together, if you don't share a common language and your interview answers feel disconnected, that combination can shift your case into deeper scrutiny. What officers are really evaluating is plausibility. Does the relationship make sense when viewed as a whole? Are there logical explanations supported by evidence, or are there gaps that feel unexplained? Couples who acknowledge their unique circumstances and proactively document them tend to fare much better than couples who ignore them and hope they won't matter. If you know someone planning to apply soon, especially if any of these factors apply to them, share this with them now. A little preparation early can prevent months or even years of stress later. Because here's where the stakes become very real. If an officer concludes that a marriage was entered into for immigration purposes only, the case isn't just denied. A formal fraud finding can be issued, and that carries consequences that extend far beyond one application. It can result in a permanent bar from future immigration benefits. It can place the foreign spouse into removal proceedings. In extreme cases, it can expose both spouses to criminal liability because marriage fraud is considered a federal offense. Now, most genuine couples will never face that level of escalation, but the seriousness of the potential consequences explains why officers are so thorough. In certain cases, especially where inconsistencies pile up, investigations can extend beyond paperwork and interviews. There have been instances of unannounced home visits where officers verify that both spouses actually live together. They may look for signs of shared life, clothing in closets, Personal items in bathrooms, evidence that two people genuinely occupy the space. These visits are not the norm for every case, but they are a possibility when fraud concerns are strong. And then there's the stage many couples assume is the finish line, the conditional green card. When a foreign spouse receives a 2-year conditional card, it can feel like the hardest part is over. Approval arrives, work authorization is secure, life moves forward, but immigration doesn't stop evaluating your marriage at that point. In many ways, the second stage can be just as demanding. Because when it's time to remove conditions, the government isn't just asking whether the marriage started in good faith. They're asking whether it has continued in good faith. And that means everything from the day of approval until the day you file again becomes part of the story. And what happens during that stage surprises a lot of people. When a couple receives a conditional green card, there's often a wave of relief. The interview is over, the approval notice arrives, the card shows up in the mail. It feels like stability. But what many couples don't realize is that a conditional green card is essentially a second checkpoint built into the system. It's not permanent status yet, it's a probationary period. 90 days before the 2-year card expires, both spouses are expected to file a petition to remove those conditions. And this stage has become one of the most underestimated parts of the entire process. Processing times are long, requests for additional evidence are common. Interviews are increasingly being scheduled again, even for couples who were previously approved without issue. And the burden of proof hasn't disappeared. It has expanded. Now, immigration isn't just asking whether you entered the marriage in good faith. They're evaluating whether the marriage has remained real and ongoing. That means everything that happened during those 2 years matters. Did you continue living together? Did you keep combining finances? Did you file taxes jointly? Did you accumulate shared responsibilities? Or did documentation quietly stop once the first approval came through? This is where some couples run into unexpected trouble. They assume the hardest part is over, so they stop keeping records. Maybe they close a joint account because it's inconvenient. Maybe they move and only one spouse's name ends up on the new lease. Maybe they simply don't think about documentation anymore because life feels normal. 2 years later, when it's time to remove conditions, they're scrambling to reconstruct proof they never intentionally preserved. And immigration looks backward. They don't just evaluate your intentions, they evaluate your documented history. Now, divorce during the conditional period complicates things even further, but it does not automatically mean the foreign spouse loses status. There are waivers available for individuals who can prove the marriage was entered in good faith, but later ended. There are also important protections for individuals who experience abuse. Immigration law includes pathways that allow certain spouses to self-petition independently if they were subjected to abuse or extreme cruelty, regardless of gender. These cases require careful documentation and strategy, but they exist specifically to prevent someone from being trapped in a dangerous situation due to immigration dependency. That's critical to understand. And while we're talking about timing and intent, we need to address another area that's receiving closer scrutiny: how the foreign spouse originally entered the United States. Because in 2026, intent is being analyzed more carefully than before. For example, fiancé visas have always required proof of a genuine relationship, but review standards have tightened. Officers are examining communication histories, travel frequency, and relationship timelines more closely. Similarly, individuals who enter the U.S. on temporary visas like tourist visas, student visas, or work visas, and later marry, must be prepared to explain their original intent at entry. Here's the nuance. Marrying after entering the United States on a temporary visa is not automatically illegal. But if officers believe that the person entered with a pre-planned intention to remain permanently while misrepresenting their purpose at the border, that can trigger allegations of misrepresentation, and misrepresentation carries serious immigration consequences. Timing patterns often raise questions. How soon after entry did the marriage occur? How quickly was the green card application filed? Were there statements made at the port of entry that conflict with later actions? These details matter. Immigration officers are trained to compare dates across documents, entry records, and applications. Consular processing applying through an embassy abroad carries its own set of risks. For individuals who have acred unlawful presence in the United States, departing the country can trigger 3-year or 10-year bars from re-entry. Waivers exist, but they require proving extreme hardship to the U.S. citizen or permanent resident spouse, and they're far from automatic. Choosing the wrong path without understanding these risks can result in years of separation. This is why strategy matters before filing, not after a problem appears. Because once a denial is issued or a fraud finding is made, fixing it becomes significantly harder than preventing it in the first place. So with all of that in mind, interviews, documentation standards, red flags, conditional reviews, entry intent, the most important question becomes practical. What can you actually do right now to protect yourself? That's exactly what we're going to break down next. So let's shift from what can go wrong to what you can actively control. Because while the system has become stricter, genuine couples still succeed every single day. The difference usually comes down to preparation, consistency, and understanding how your relationship is being evaluated. First, document your relationship naturally from the beginning, not just when immigration paperwork starts. That means keeping photos from ordinary days, not just weddings and vacations. Save travel confirmations. Keep records of shared plans. If you live together, maintain documents that show both names tied to the same address. If you're long distance, preserve communication history in a way that shows progression over time. You're not building a performance, you're preserving a timeline. Second, be completely honest on every form and in every interview. Trying to hide a prior overstay, a previous visa denial, or a complicated timeline almost always creates more damage than the truth would have. Officers have access to extensive records. Inconsistencies, even small ones, can undermine credibility, and once credibility is questioned, every other piece of your case becomes harder to defend. Third, prepare for interviews thoughtfully. Review what you submitted. Go over your timeline together. Make sure both of you are comfortable describing how you met, how the relationship developed, major milestones, and daily routines, not in a rehearsed way, in a familiar way. You should sound like two people who share a life, not two people reciting notes. Fourth, if you receive a request for additional evidence, treat it as an opportunity instead of a disaster. Read it carefully, respond fully, provide organized documentation that directly addresses what the officer asked for. Missing a deadline or submitting a rushed response can turn a fixable situation into a denial. Fifth, keep building evidence throughout the entire process, especially if you have a conditional green card. Continue combining finances where appropriate. Continue documenting shared experiences. Continue filing taxes correctly. Immigration cases often stretch over years. Your documentation should reflect growth, not stagnation. Sixth, understand the financial sponsorship requirement clearly. The sponsoring spouse must demonstrate the ability to financially support the immigrant spouse at a certain income threshold. This doesn't require wealth, but it does require meeting specific guidelines or using a qualified joint sponsor. Overlooking this requirement causes preventable delays. And finally, recognize when professional guidance may be worth the investment. Not every case requires an attorney, but if your situation involves red flags, prior immigration violations, criminal history, complex financial sponsorship issues, or divorce during conditional status, experienced legal advice can prevent mistakes that are extremely difficult to undo. The overall theme here is simple but powerful. Treat your immigration case as a documented history of your shared life, not just a stack of forms. Officers are looking for consistency between your story, your paperwork, and your real-world circumstances. When those three elements align, cases move more smoothly. When they don't, scrutiny increases. Marriage-based green cards remain one of the most common and legitimate pathways to permanent residence in the United States. Genuine couples are approved every day, but the 2026 enforcement environment demands more awareness than before. It demands that you understand how timing, documentation, red flags, and credibility all interact. Love may be the foundation of your relationship, but evidence is the foundation of your case. If this helped you see the process with more clarity, make sure you're subscribed to Global Visa Guide so you don't miss future guides and updates as policies continue to evolve. And if you have questions or want a specific topic covered in detail, leave a comment below. I read them, and they often shape what we discuss next. Immigration rules change, enforcement priorities shift, but preparation, honesty, and documentation will always be within your control. Stay informed, stay organized, and protect your future.